This is the 15th meeting of the Standing Committee on Public Safety and National Security. I would like to announce at the beginning here that once we begin our meeting, the media will have to vacate the room. We are dealing with Standing Order 1082, the study of the report of the Commission of Inquiry into the events relating to Mahar Arar. And we would like to welcome as our witness the former Solicitor General, the Honourable Wayne Easter. We thank you very much, sir, for appearing before this committee. We are honoured with your presence. We look forward to your testimony. The usual procedure is to give you whatever time you need, 10 minutes or whatever. We're not going to be too tight on that. And then, of course, you know how it works with questioning of so on, beginning with the official opposition, ending up with the government. So, if you are ready, sir, we will turn the microphone over to you.
Thank you, Mr. Chair. I think 10 minutes opening should adequately do it, perhaps not quite that. So I have prepared a statement in opening, Mr. Chair. First of all, thank you, Mr. Chairman, and committee members for the opportunity to appear before the committee. During my tenure as Solicitor General of Canada, as I pointed out in testimony before the Commission of Inquiry, I was engaged in a number of the initiatives which Justice O'Connor has identified in his report, the most critical being a more secure and mutually agreed-upon code of conduct with respect to the sharing of information with foreign governments and agencies, most critically the United States. From my review of the evidence presented to the committee, the specific reason for the committee's request for my testimony surrounds evidence presented by the Commissioner of the RCMP on September 28th of this year. I will try and speak directly to that matter. The Commissioner testified to the following, and I'll quote directly from the evidence of this committee. At page 3 of the evidence, the Commissioner stated, and I quote, "I personally became directly involved in the file after Mr. Arar was detained and sent to Syria," end of quote. The Commissioner went on to state, still at page 3 in the testimony, quote, "I found out that investigators were speaking with American officials while he was in detention. As part of that discussion or that correspondence with RCMP officials, I learned that in this process they tried to correct what was labelled as false or incorrect information with regard to Mr. Arar," end of quote. Apparently, according to the Commissioner, there had been an effort by the RCMP to correct the information prior to the deportation of Mr. Arar, which would place the time sequence between the end of September and very early in October. At page 4 of the evidence of the committee, the Commissioner made the following statement, quote, "When we learned what had occurred, we had discussions with the Minister to inform him of the situation," end of quote. I must assume the Commissioner is referring to the discovery of what has been described as false information having been conveyed to officials in the United States. I'd like to address this latter point insofar as it applies to myself as Solicitor General at the time. Given that the Commissioner in testifying before this committee did not provide, insofar as I am aware, any specific time frame within which this information was conveyed to me as Minister, I will speak to what I have established from a review of the record and discussions with staff who would have been present at any such meetings. However, I would begin with a quote from Justice O'Connor's report as providing context for the following. At page 29 in the analysis and recommendations of the report, Justice O'Connor writes, and I quote, "While the project," referring to Project AO Canada, "pointed out that it was unable to indicate links between Mr. Arar and al-Qaeda, it did not go further and correct the inaccurate information already provided to the American agencies about Mr. Arar, including the label of Islamic extremist," end of quote. I would advise the committee that I had the opportunity of examining again the documentation which had been available to me as Solicitor General, and I did that yesterday. I have reviewed the relevant briefing materials which had been prepared for me, which included briefing notes and house book cards. While I'm not at liberty to reveal the specific contents of the documents in question, I would advise the committee that the material in question has been available to Justice O'Connor, and I did testify to the contents of the material before the Commission, for the most part in camera. As an aside, Mr. Chair, the dilemma for MPs on this committee, I think, makes the argument for a parliamentary oversight committee with the power to access national security documents, cabinet documents, etc., under certain conditions, as recommended to government by a committee that I sat on and a number of you around this table sat on. I think if there's ever an instance where MPs, under certain conditions, need to access those documents, it's this one. Because both you, we're all at a disadvantage when we're dealing with documents that some of us have seen and some of us can't see. However, if the committee is able to gain access to the following documentation, the issue as to whether I, as Solicitor General, was appraised of the errors and to the false information not only having been conveyed to the United States authorities, but that a concerted effort had been undertaken to correct such information, will be made abundantly clear to you. I was not so informed, and I will state that again. I was not so informed. Prior to my assuming office on October 22nd, I have identified that 2 briefing notes have been prepared for the Commissioner of the RCMP. Justice O'Connor makes a reference to one of October 9th, 2002, and that's on page 177 of Volume 1 of the factual background material. Justice O'Connor makes no reference to any errors or corrective measures. In the briefing note of October 18th, 2002, made reference to by Justice O'Connor at page 498 on Volume 2 of the factual background material, there again is no reference to the Commissioner having been informed of any errors or corrective measures being taken. Thus, upon assuming my office, the record, in as far as I have examined the briefing notes prepared for the Commissioner, provide absolutely no indication that the information was incorrect that had been conveyed to the United States. The first occasion upon my having assumed the office of Solicitor General of being made aware of the Aurora file, was presented to me in a House book card. The House book card is prepared for ministers by officials of their relevant departments and agencies in anticipation of questions in the House. The RCMP prepared this specific card. It's dated October 25th, 2002. As well, there is an updated card dated November 15th, 2002. There was no reference to errors in information, no reference to false information, nor was there any reference to any corrective efforts having been made by the RCMP with respect to any of the information which may have been shared. On June 26, 2003, my office requested from the RCMP a briefing note on the Aurora file. In the briefing note prepared by the RCMP for the Solicitor General dated June 27, 2003, there is no reference to the RCMP having been aware of having provided erroneous or inaccurate information to the United States, nor is there any reference to efforts by the RCMP at corrective measures of any kind related to information conveyed to United States authorities. In a briefing note prepared for my office dated July 10, 2003, in preparation for a meeting I was to have with United States Attorney General John Ashcroft, there again is no reference to inaccurate information or corrective measures which the RCMP had undertaken with United States officials. One would assume that the Solicitor General would have been made aware if, in fact, senior officials in the RCMP had been aware that erroneous information had not only been conveyed to the U.S., but that U.S. authorities answering to the Attorney General would have made him aware of the errors resulting in the detention and deportation of Mr. Herrera. Maybe as he made him aware of the errors allegedly resulting in the detention and the errors that allegedly resulted in that detention. Attorney General Ashcroft, had that been the case, would undoubtedly have raised that point with me. As part of my purpose for the meeting with Attorney General Ashcroft was to express my displeasure at what had happened to Mr. Herrera at the hands of the U.S. So I certainly feel very confident that if I'd have went to the U.S., basically gave Attorney General Ashcroft hell for the handling of Mr. Herrera and his deportation to Syria, I really believe that given my relationship that I had with the Attorney General, that he would have on no uncertain terms said to me, "But Wayne, you provided us with misinformation." And that never happened, Mr. Chair. The actions I undertook as Solicitor General with respect to the case of Mr. Herrera were based upon the advice provided by officials with the RCMP and CSIS. If errors are made and corrective measures required or taken, it is the expectation of any minister that they will be informed of those situations. Now, Mr. Chair, I think all you around this committee, as I do, recognize that there is some difficulty between the information flow as it relates to the Solicitor General and the RCMP because we don't operate the same way as they do in the U.S. Solicitor Generals are not informed of operation, and that's the nature of the job. Whereas as it relates to security matters with CSIS, you in fact are. So the Solicitor General does not get into operational matters as such. As Solicitor General, I was operating on the fact that Mr. Herrera had been and remained a person of interest. I am in complete accord with the following statement found at page 69 of Justice O'Connor's report, and I quote, "I have no reason to believe that it was not appropriate throughout the relevant time period for the RCMP as a law enforcement agency continue its main investigation, in which Mr. Herrera came to the investigators' attention from time to time," end quote. On page 18 and 19, Justice O'Connor further refers to Mr. Herrera as properly a person of interest in two other contexts. I would make one final point, and that relates to information held by the United States on Mr. Herrera. At page 156 of Justice O'Connor's report, he states, and I quote, "The question arises as to whether the American authorities relied upon information provided by the RCMP in making the removal order. Without the evidence of the American authorities or access to the classified addendum to the removal order, I cannot be sure what information they used," end of quote. The Commissioner of the RCMP in testimony before this committee stated at page 14 of the evidence on September 28, 2006 that, quote, "We cannot be 100% sure of the reasons why the Americans made the decision to send Mr. Herrera to Syria. According to Justice O'Connor's report, it is not exact to say that they acted only on the basis of information conveyed by Canada," end of quote. I might say in conclusion, Mr. Chair, that as it relates to Justice O'Connor's report and his recommendations, I do believe that Justice O'Connor did an excellent report. I advise people not to just read the parts of it that are somewhat sensationalized in the media, but to read the whole report. There's a lot of information in that report, and as I've said publicly, I do agree with the recommendations that Justice O'Connor makes. and especially, and we'll see what he does in his second report, but certainly believe that there does have to be a different, based in my experience, a different oversight agency for the RCMP. Based on my experience, the RCMP in the McDonald Commission was recommended to get out of National Security Matters. As a result of 9/11, they started getting back into security matters, and therefore I think it does require a different kind of oversight body. In fact, we were working on that during my term as Solicitor General. It never came to be complete. But it does, I will say this, it does require different oversight, somewhat closer to the CSIS arrangement, but maybe something in between. So I just conclude on that point. So thank you, and I'm open for questions.
Thank you very much, sir, and you have given us lots of material there. I'm sure that there will be plenty of questions. I would like to ask the committee's permission to go to 5-minute rounds. Looking at the clock, I think in order to get around to everyone, would anybody object to going to 5-minute rounds? Otherwise, there will be many here. Okay.
No, I do object.
You want a 7-minute?
In the opening round, yes.
Okay. All right. Surprised I didn't get permission, but we'll move ahead then. Mr. Holland.
Thank you, Mr. Chairman, and thank you, Mr. Easterbrook, for appearing before the committee. I'm wondering if we could begin in May of 2003 when there were discussions of preparing a one-voice letter. And this would say to the Canadian government, or would say that the Canadian government had no reason to suspect Mr. Arar was involved in terrorism. And I wanted to confirm again that the RCMP Deputy Commissioner had advised you not to sign that. Secondly, did you receive similar advice and direction from CSIS? And in advising you not to sign, did they lead you to believe or give information at that time that there was still reason to think that Mr. Arar was a terrorist, or there was information to believe that he was a terrorist?
The advice coming forward to me from both parties in question was not to sign the letter. My own judgment as well was not to sign the letter because, as is stated and is in fact agreed to by Justice O'Connor, Mr. Arar, under the conditions that we were operating in, was considered a person of interest during the whole time. Fact of the matter is, as well, I personally believe too much is read into the letter that if the Solicitor General would have signed off on that, our body, in the way that Canada acts, our face abroad is through the Minister of Foreign Affairs and the Prime Minister. And I believe at the end of the day the best approach was taken, that the Prime Minister did sign a letter, and that's what the letter was. That's the letter that was conveyed abroad.
You say at that time, though, that the RCMP was still at that point giving to you as the Solicitor General information that would that stated or would lead you to believe that there was still a possibility of being considering Mr. Arar a terrorist. I mean, was that continuing to be their position? In other words, the concerns that were raised by Justice O'Connor in terms of the information that was flowing forward at the time that letter was put in front of you, was the RCMP still conveying that same concern, that same the same directive that he was a person of interest and that he was a potential terrorist?
The information that was conveyed to me, as I indicated earlier, and that is again confirmed by Mr. O'Connor, really relates to not so much the aspect that you're talking about as Mr. Arar was a terrorist, as the fact that he was a person of interest. And that's basically what was provided to me, that he was a person of interest, and that's what it indicated in briefing notes relative to the matter as well.
and not to belabor this, but I just want to be clear. So there was not an impression at that point that they were giving that Mr. Arar had terrorist links at that point in time?
Not an impression given to me. I think if you go back to the O'Connor report in terms of some of the information that was exchanged with the U.S., you could draw that impression from that exchange that was with them, with their authorities. But Mr. O'Connor, and I would point this out, that Justice O'Connor in his report also indicates, and I can find it in here, but basically, Mr. Chair, that there was not malicious intent in doing that, and I'll find that information.
When Mr. Zaccardelli testified before this committee in September, I want to go to a couple of the comments that he made. One of them surrounds asking if the RCMP ever admitted that they had made a mistake. When Mr. Zaccardelli testified before this committee in September, he stated that the RCMP corrected the inaccurate information that they had been provided to the United States as soon as they were aware of it, and further said, when we learned of what had occurred, we had discussions with the minister to inform him of that situation. Can you comment as to whether or not Mr. Zaccardelli did inform you in the manner in which he testified before the committee?
Well, I've read that testimony closely of Commissioner Zaccardelli's, and that's why, in terms of my opening remarks, Mr. Chair, I dwelled on that point so much. The fact is that no, I was not informed by briefing note, by House book card, or by any other measure that the RCMP had provided misinformation. Now, and I think this is a question that you're basically going to have to raise with the Commissioner again. I wonder if people are reading too much into the Commissioner's statement before this committee. But in any event, I make it clear, and I went back through all the documents. I've discussed with people who were my staff at the time, and there is no situation where the RCMP came to me and basically said, we screwed up, we provided improper information, and that information certainly never came forward to me.
And I suggest that's certainly a matter the committee would want to come back to. I'm going to press forward, though, with questions now. That's fine. Yeah, appreciate that. This is questions with regards to the leaks in 2003. In July of 2003 and afterwards, there were many leaks that appeared to the media that suggested Mr. Arar had terrorist links. And, of course, some of these leaks were still occurring when Mr. Arar was in Syria. A number of them occurring in October of 2003, even after Mr. Arar had returned to Canada. I guess the question is, do you have any information suggesting which agency or department or which individuals those leaks might have come from?
No. No, I do not. Simple answer is no, Mr. Chairman. I had asked myself as soon as there was leaks out there. That an investigation occur within the departments that I was responsible for. That investigation did in fact take place, and you know the result. There was nothing found.
Thank you, sir. And we'll now move to the Bloc Québécois. Monsieur Menard.
Thank you, Mr. Chairman. If I understand correctly, based on an expression you've often used, a person of interest, to your knowledge, up to a certain point, Mr. Zaccardelli said that he himself was persuaded that Mr. Arar was innocent of any dealings with terrorist movements.
Basically, I'm not really clear on your question, Serge, but basically, to my knowledge and information provided to me, right up until probably November 2003, where the briefings did in fact get more extensive and the background was provided. But during the whole time, Mr. Arar was considered a person of interest, and that was that.
Oui, mais c'est l'expression que vous utilisez toujours.
Well, the expression you use, the person of interest, yes, but to your mind, is a person of interest someone who's has dealings or associations with a terrorist movement or group, or is it a person who is not known to have dealings with the terrorist groups, but who has contacts with them, who may be innocent? Or has there been an indication there was a relationship with a terrorist movement in a person of interest?
To me, there was no indication until, as I said, until a very extensive briefing in November 2003 that there was anything more to Mr. Arar than he was a person of interest. That's the bottom line, that he was just a person of interest, not peripheral to another investigation. I guess I could put it that way, peripheral to another investigation.
But that's what I'm trying to determine. A person of interest can be someone who has been seen to have dealings with terrorist groups or contacts with terrorist groups without being able to determine whether those contacts were innocent or were for purposes of terrorist activity. For example, someone who rents premises from an owner, well, the owner, for example, has contacts with a person who rents his premises, but may not know that the person who rented the premises is a terrorist. So is that what you thought? Or did you believe that Mr. Arar might indeed be involved in terrorist activity?
The fact of the matter is that there was, and I'm not, one of the difficulties, Mr. Chair, is that, and I will say, I am disappointed in the clerk of the Privy Council. I asked the clerk of the Privy Council for advice or assistance in what is considered to be national security issue, what is considered operational, and what's considered secret. And I'm at a bit of difficulty which is which in my own mind, even though I went through some documents yesterday, some of which have been declassified, some of which have been not. But in any event, I guess I'd put it this way, Serge, the fact of the matter is, and the Americans were informed of this, and I did have knowledge of this, is that there was, that we had no evidence on Mr. Arar of which to make an arrest within Canada if he was here. That he was considered to be, as I indicated, a person of interest, as a result of, and it's mentioned in Justice O'Connor's report, the interest due to his connection to other subjects who were involved in other activity, in terrorist activity.
En fait, vous ne saviez pas.
In fact, you did not know that Mr. Zaccardelli was convinced Mr. Arar was innocent, completely innocent of any dealings with terrorists and their activities.
As I did not, as I indicated in my opening submission, that I was not informed that RCMP had provided inaccurate information to the U.S. And I've outlined that fairly extensively, and I would advise the committee, if they can access any of those documents that I've outlined, then do so, and I think you'll come to the same conclusion. And I, in particular, especially when I was going to meet Attorney General Ashcroft, and we were very disappointed, angered, and frustrated at the United States and how they had treated Mr. Arar. He should have been sent back to Canada. Attorney General Ashcroft certainly never said to me, but I've been informed that Canada has provided us with misinformation. He never raised that with me. I know the man, and I know he certainly would have raised it with me if I'd have...
J'aurais obligé de poser une question suggestive.
So I have to ask a very suggestive or hypothetical question. Would you have known, Mr. had you known, or could you have known that Mr. Zaccardelli thought him innocent? If you had known that, would your attitude have been different, and would the actions you took to have him released have been different?
I don't think now is the time, Serge, to get into hypotheticals. The fact is, the best report on this matter, the individual with access to, with more information than anybody else from all the sources, is Justice O'Connor. Justice O'Connor does not, he maintains the person of interest approach throughout his document. He outlines some of the errors, but I think it'd be inappropriate for me to get back into hypotheticals of what would have happened if. The fact of the matter is they didn't.
Martin, for 7 minutes.
Thank you, Mr. Chair. Thank you, Mr. Easter, for being here. I just want on that last point, though, it seems to me Justice O'Connor was quite critical of both the RCMP and CSIS for not taking part in letting that letter go from DFATE. I'll make that just as a comment. Could I ask you to turn to page 28 of the report, the volume on analysis and recommendation? It already referred to page 29.
Yeah.
In the second last paragraph at the bottom, I'm on 28.
Yeah.
Second last paragraph at the bottom. It starts on October the 3rd, 2002. There's material blanked out there.
Yeah.
Are you able, recognizing the constraints that you're operating under in terms of national security, are you able to tell us whether you were the person who requested that information that's referred to in that paragraph?
No, I was not the person that requested that information, but I would point out on your first comment, Mr. Comartin, that that yes, Justice O'Connor is critical of the RCMP and CSIS not recommending the letter, but he also states in this report that he understands why they did. Basically, I'll try and find that. But if you
no, I agree with that. Don't bother. I agree with that characterization. But he's still critical.
He still is critical.
He understands the constraints that you're operating under. So let me go to that point. At that period of time, if we accept your evidence today, at that period of time, you were still operating as the minister under the impression that Mr. Arar, again, and I'm referring to the comment, the quote that you gave from the report on page 29, that he was still labeled in the minds of the RCMP as an Islamic extremist. You have never been told, up to the time of that letter, that assessment by the RCMP had changed. Is that correct? In the minds of the RCMP, at the time of that letter, in your belief, not necessarily theirs, because we think now, in fact, I think we know now that that was not their belief at the time, but they didn't tell you that. So at the time of that letter, you still believe that Mr. Arar was an Islamic fundamentalist or extremist, using their terminology.
No, because the information provided to me, and I would have to go back to the documents to be absolutely sure, the information provided to me stopped at person of interest. Did not include Islamic terrorist.
So throughout the entire period of time that you were minister and responsible for the RCMP, you never saw any documentation that characterized Mr. Arar as an Islamic extremist?
Not up until, as I indicated earlier, about, I would say, in November of 2003.
So after the whole...
Possibly. And this is the difficulty, Mr. Chair, that we don't know the documents. Would have been possibly in July, but I don't think so. I think it was November before the word Islamic terrorist extremist came to my attention from the RCMP.
Okay. And in terms of your knowledge as to when... I'm sorry, let me change that. When did you first become aware that that information was incorrect? Was it at the O'Connor, when the O'Connor report came out, sometime during the hearings? When did you first become aware that that classification of Mr. Arar was in fact false?
During the O'Connor inquiry.
By reviewing documentation or because of evidence that came out of it?
Because of evidence that came out.
In terms of, just to close off other avenues here, in terms of the chain of command, in terms of communications, is it possible that the RCMP, either the commissioner or senior members, communicated with deputy ministers within the Solicitor General's office, that information that didn't come to you regarding this particular issue?
I think it's probably it is possible.
Have you discussed with your deputy ministers whether they had that information communicated to them, that this information on Mr. Arar was false or misleading?
No, not recently.
How many deputy ministers would there have been during this period of time when the Arar case was going on?
Just one with me.
And who was that?
Nicole Javin.
Okay. And then, Mr. Easter, in terms of communications, you talked about documentation, the house book card, and other memos that came to you from the RCMP. Were there any verbal communications to you that the information the RCMP initially had on Mr. Arar was false or misleading?
No. No, and I've indicated that in my opening statement, and I've checked that as well with other people that would have been with me in those verbal communications.
In terms of your recollection in this regard, how would you categorize the Arar case in terms of its seriousness for your department and you personally as a minister?
It was in the early period, November, December, January 2002, one of many. But the issue did take on increasing criticalness as the months progressed.
Unfortunately, we're out of time. Thank you, Mr. Comartin. And we'll now move over to the government side. Mr. McKenzie, please.
Chair, and thank you, Mr. Easter. I am a little bit confused. I think there's an article in one of the media today indicating that you first knew about this erroneously labeled information only a month ago. And if I understood your response to Mr. Colmartin, you actually knew about it back when the O'Connor...
To Mr. O'Connor was when the report came down.
Oh, okay, I'm sorry. I thought it was during the hearing. Fine. Now, you were the Solicitor General. You were not an MP in the House, or just an MP in the House. When you were aware of the seriousness, and I think, you know, we accept very much that initially this was probably a little bit under the radar because of one of many things, and I think we've heard that same line basically from the Commissioner. Excuse me. But once it began to take on some importance, did you never question anyone, the Commissioner or anyone in your ministry, about were they sure of the accuracy of the information that was used? And when you were going to the U.S. to talk to them, you had to feel
yes,
that you needed to have the information.
Yes, Mr. Pickensy, absolutely. We asked, and especially in the spring of 2003, prior to going to a meeting with Attorney General Ashcroft, we asked for a full briefing. We asked tough questions on Mr. Arar because it was a public issue. We were concerned about the detention and deportation, and there was lots of questions asked. Yes.
And it would have been of the Commissioner?
Either off the way that it could have been off the Commissioner, could have been off off both really, Deputy Commissioner Lepsky and Commissioner Zaccardelli, and others who may have attended with the Commissioner and Deputy Commissioner.
So there'd be no question in 2003, mid-2003, that those hard questions were being asked about the authenticity of the information that was passed to the Americans, and at that time there was never any suggestion that there had been an error?
No, and this is when you go through O'Connor's report, it would be absolutely amazing to me if there had been errors admitted to in any material or in conversations that it wouldn't be included in Mr. O'Connor's report, Justice O'Connor's report, and it's not. Other than to say the ministers weren't provided with perhaps all the information. And I mean, I would think, given Justice O'Connor's report and the availability of documentations, I mean, there's thousands of pages, the availability of documentation from so many sources, that he would certainly raise it in his report if it had been admitted to.
Not questioning that, all I just want to be certain that the questions were actually asked and either a denial or misinformation was provided by the officials at that time.
I think one of the things you, as I indicated in the beginning as well, one of the difficulties here is RCMP Solicitor General relationship in terms of operations. And yes, hard questions were asked, but I think the response, basically along the lines, the facts are as were provided to me in briefing notes and house book cards.
Okay. And the same scenario was that while this was going on, there was the talk of the one voice letter. Obviously, this was not a run-of-the-mill situation by that point. And did that relationship between the Solicitor General and the RCMP change in any way, shape, or form where they became more willing to talk, if you will, to the Solicitor General about what was going on? Because this issue had gotten larger than law enforcement then. It had crossed international boundaries, and it was a major issue in many minds. Still no indication that errors had been made in information passed to the American authorities?
No, not on errors being made in terms of, as I indicated to other questioners earlier, there was certainly more extensive briefings as time went on some of the background and parameters around Mr. Arar and why he was a person of interest. That was not till about November, I believe, in 2003.
Okay. And when you became aware of the information flow between the Canadian authorities and the Americans, as Solicitor General, did anyone, either yourself or any of your officials, confirm that the caveats that are supposed to be in place were, in fact, adhered to?
I think the assumption was made that they were. I think one of the requirements is certainly that there be a flow of information between the various law enforcement agencies between our two countries and the security agency. I mean, that's important that there is a flow of information. I actually believe that part of the problem here in that information flow, and it relates to what I said earlier in terms of the RCMP getting back into to a great extent national security issues, is that it's two different. It is two different individuals. Policemen tend to take information, gather it, lay a charge, provide it to the courts to deal with. That's not the way that security matters operate, so you had to be absolutely sure that the information is accurate and has the checks and balances. And I think Mr. O'Connor certainly has recommended that, and I agree with that 100%.
Now to the next round, the Liberal Party, Mr. Algafra, please.
And good morning, Mr. Easter. Thank you for coming here. I want to go back to the question of the leaks. In July 2003, there, as you mentioned, and as the committee knows, there are several leaks that were made and alleging, including items as that Mr. Arar had traveled to Afghanistan and had some activities related to terrorist activities. As a Solicitor General, were you ever briefed on those allegations, whether the fact that, yes, those things that the RCMP believed, or no, we don't know where these leaks came from and they're containing inaccurate information?
As Solicitor General, as I indicated earlier, Omar, I asked when the leaks occurred and whether they were accurate or inaccurate. I asked for an investigation to be held within all our branches, which would have been including CSIS, RCMP. I believe there was further investigations elsewhere, whether the leaks could have come out of Foreign Affairs or Privy Council, and that investigation did occur. And as is well known, the investigation led nowhere and had no results.
But if you allow me, I'm curious. The leaks happened. I'm curious if you were ever briefed. You could have been briefed on two things: whether the fact that those are informations that the RCMP had believed that it actually happened, or once the RCMP officials have realized those leaks are inaccurate, did they ever brief you that those leaks are inaccurate, those are things that we don't really believe?
We stuck to the fact that if there was trying to find out whether or not that there was leaks. There's all kinds of information out there. Some of it's accurate, some of it's inaccurate, probably. But the key for us is what information, if any information, was being coming out of offices under our responsibility or from the government as a whole, and that's what was key to us. That somebody was somewhere using information, accurate or otherwise, to undermine the credibility of Mr. Herrera, and that was our concern.
You know, the attitude at the time in 2003, before and after, during the whole situation, caused by leaks, and I also recall opposition members. Do you recall at the time there were the alliance? What type of impact? What type of questions they had for the government? What kind of pressure they exerted on the government, and what type of impact did that have on the government and your office?
Well, certainly on the questions on the file. Let's put it that way. We're ranged all over the map. They ranged from questions by, I believe, Mr. Day and others at the time, that we weren't that the government wasn't tough enough on terrorists, whether that was referring to any of the people that were in the news at that time. I would have to go back and look, but certainly there was very tough questions from Mr. Day that we weren't doing enough on fighting terrorism. There was questions from the other side, in particular the NDP, saying that we weren't doing enough to protect civil liberties. So they ranged right across the mat.
So
I think we have a shorter round this time, and if we're going to get around, we'll have to move to Mr. Menard from the block. Thank you.
I'd like us to agree on our terminology, Mr. Easter, and what the terms mean. A person of interest and a terrorist extremist and an Islamic terrorist, to you, are different things. Is that correct?
Bon. Si j'ai bien...
Agreed.
I think though, Mr. Menard, a person of interest could lead anywhere to being absolute innocence, to being a terrorist. I mean, it could lead in any direction. It means that there's information there that leads a law enforcement agency to have an interest in this individual based on connections or whatever else that may lead somewhere. Maybe good, maybe bad.
Maintenant, si j'ai bien compris votre réponse à M. Comar.
If I properly understood your answer to Mr. Comartin, until November 2003, or until July 2003, you don't seem sure of the exact date, as far as you were concerned, Mr. Arar had always been described as a person of interest, but not as an terrorist extremist or an Islamic terrorist. Is that correct? So, when he was described as a terrorist extremist terrorist, or Islamic terrorist, either in November or July 2003, that description came from the RCMP.
Yes, I believe it did. Yes.
OK. Alors,
bit on that, Mr. Menard, that would have been very late in my time as Solicitor General,
okay.
And that would have been at least their allegation at one point in time.
Okay. Je me trompe en pensant, M. Easter,
am I wrong in thinking that an extremist or Islamic terrorist was sent to Syria by the U.S. authorities? That fact is much less surprising to you than just a person of interest being sent there, someone who was not an extremist terrorist.
The fact of the matter is that, and I've answered this a number of times, and O'Connor goes into this as well, that there was no officials, not the RCMP, not CSIS, involved in the decision by the Americans to deport. Mr. Justice O'Connor indicates that that the information provided of Canada likely was a part of that, likely was one of the reasons for that decision, but elsewhere in the report he indicates that there was information globally as well.
Your final question, Mr. Menard.
Si je reviens en arrière,
So if I go back to your relations with Mr. Ashcroft of the United States, had you known that Mr. Arar was innocent of any dealings with terrorist activity, you would have said so to Mr. Ashcroft and asked Mr. Ashcroft why Mr. Arar had been sent to Syria, to know whether they had their own reasons for sending him to Syria. That's my last question. If they had their own reasons for sending him to Syria, you would have asked. Even though he came from Syria originally, he was a Canadian citizen, so it would have been good to know whether he was an extremist terrorist or simply an innocent person.
Yes, just let's be absolutely clear. With respect to Mr. Arar and the decision by the U.S. To detain and deport, we did complain strenuously to the U.S., to Mr. Ashcroft. We operated, or I did at least, operated on that they violated, in my view, international law in terms of what they did. Mr. Arar was innocent from my point of view, and should not have been detained and deported to Syria. We made that very clear to Ashcroft. We asked the questions: why did you deport him? But no answers were forthcoming. Mr. Ashcroft would maintain they did it under their laws and they had the right to do so. I disagree with that, and we argued that point strenuously.
Thank you, Mr. Brown, for a brief round. With your permission, Mr. Easter, we're going to go over a few minutes. Is that all right?
Not a problem.
Okay, last question.
Okay, thank you, Mr. Chairman, and Mr. Easter, always good to see you. Thanks for coming today. I have many questions and only a few minutes to ask them, so I'll fire off pretty quickly here. First of all, from your information, do you believe that the United States was investigating Mr. Arar, or did they rely solely on information from the RCMP?
I think the problem is we get into judgment calls here, Mr. Chair. Justice O'Connor covers that in some detail, but I can tell you this absolutely, because and it's quoted in, I think, Volume 3. Attorney General Ashcroft indicated to me that no, the information was not just from Canada.
So there was other information. You talked about questions from the opposition. Was there questions from your own party about Mr. Arar? And
there was questions from all parties. Yes.
And what were the tone of the questions from your own party?
Well, they ranged across the map. In my own party, they would range from basically. From the civil liberty point of view to are we doing enough to fight the national security issues worldwide?
Okay, and why did the government block for many months efforts to free Arar?
The government did not block the efforts to free Arar from the very beginning. And this would be a better question for Foreign Affairs, but from the very beginning, Foreign Affairs worked in New York to try and make sure that ensure that Arar came to Canada. We were under the opinion that Arar would be coming to Montreal, and Foreign Affairs and the Prime Minister's office worked strenuously to get Arar back to Canada, and I do believe that if it wasn't for those efforts, Arar might not be here yet.
Well, then, if that's the case, then why did the government not probe more strenuously the case between the RCMP that was against Arar? Why were they not trying to get to the bottom of it more than they did?
Well, I think
you were counting on information from the RCMP, but clearly you didn't probe that enough, in my view.
Well, I think we certainly did probe it. We raised the questions with the RCMP that needed to be raised. I think the best source of whether or not we were strenuous enough is to go to Justice O'Connor's report. He's the one that has all the information, and there is, I think, yes, there's some lessons learned. And that's why I agree with all the recommendations that Justice O'Connor suggests. And further, as I indicated earlier as well, I do believe there has to be a different kind of oversight agency.
Okay, well, that's one of my questions. But like Mr. Algebra, I'm very concerned about these leaks. Why do you think that they didn't get to the bottom of that? Because these leaks were damaging and have led us to where we are today, in large part, from my perspective.
Well, I think if you go back to Commissioner Zaccardelli's testimony, he indicated that one of the most difficult investigations is leaks. But I do know that there was a very strenuous investigation into the leaks, and that's probably ongoing. So that's a question that this committee asked Commissioner Zaccardelli, and he's far better to answer that than I.
Okay.
Other than to say that we were very concerned about the leaks right up to the Prime Minister's office, and the investigations did take place, they did occur. But I still have to admit there's no answers to that.
Okay, thank you. And I think I'll get one more in here. I just want to ask, will you support the creation of a National Security Oversight Committee?
Well, we'll have to see what the committee looks like when it comes out in structure and form. I sat, as a number of other committee members around here did, on a committee that looked at oversight. And made some recommendations in that regard. And as I said in the beginning, we definitely need one in this country.
Okay, thank you.
Thank you very much, and appreciate you coming before the committee, Mr. Easter. The time has gone by very quickly. I thank all members here for the questions that they have posed. This meeting stands adjourned until we stand adjourned. Meet again Thursday.